And that's what normally you would expect to see in an estate that's got some size, more than just a house probably, you know, some assets in there, real estate, oil and gas interest, money, stocks and bonds, those kinds of things. And it does several things. It's an upfront kind of deal where the people that really own the assets say, this is what I have, and they make a list, and the list gets attached to the trust, and then everyone knows that's going to be involved knows what those people own. You completely avoid probate with that, so you don't have to go down to the courthouse, take care of anything. There have been deeds that have transferred real estate, bank accounts that have been changed to reflect the trust ownership, so that when the trustee usually is also the grantor. That's just the name of the person who made the trust, the grantor. When that person dies, or when the spouse, the final spouse to die, passes away, then everybody has the list. All the property's been transferred and owned by the trust. So all you have to do at that point is take it down to a lawyer of the survivor's choice, the heir's choice, or the lawyer that drafted the trust, and go through the process, which is very quick, to make that final transfer from the trustee of the trust over to the individuals that are the heirs that are supposed to get the property. And again, no probate or anything like that's involved. Now, you don't avoid the estate tax if it's above these minimums that we've talked about, but you do avoid all the probate, all the publications in the newspaper, and all that kind of thing with a trust. And then also with a trust, we normally would do a durable power of attorney for the people making the trust. And what that does is, if someone, with a durable power of attorney, what happens in that instance is, let's say that my wife and I have a revocable trust and we have durable powers of attorney back and forth between the two of us. If I pull out here on Kelly, one of the busiest streets in town this afternoon, and somebody T-bones me, and unfortunately I don't die, I just become a vegetable, with a durable power of attorney, she can continue to deal with all the things that need to be dealt with respect to me, like life insurance, CDs or IRAs or whatever else might be out there that need to be dealt with. So we would normally do a durable power of attorney. We would prepare the wills to, quote, fund the trust so that all the property is transferred into the trust. Because sometimes people will make a trust and then they won't fund it. And when you do that, you've got the worst of all worlds, because you front-end loaded the cost on that by having a lawyer draft these instruments, and you back-end loaded it as well because you didn't fund it, so you're still looking at having to do a probate. So you never want to do a trust and not fund it, because you haven't gained anything there. You have a trust, but it doesn't really have any meaning or bearing or effect on anything. So you have to fund it as well. That's another plus, though, because by doing that funding, again, you've relieved your heirs of having to go out and marshal and find those assets, bring them into a probate situation, and make transfers at that point. You've already done that for them. So again, you front-end loaded your cost with the attorney's fees and whatnot, filing fees with county clerks and people of that sort. But you've avoided probate, so you have no back-end costs hardly at all, except maybe a deed filing from the trust to an heir or something like that. So the irrevocable trust works really well. And there are some other kinds of trust. You can have a testamentary trust, which you can include in a will. Let's say you're just getting started and you've just gotten married. You don't have a lot of assets built up. You might do a will that's a little more complex than a simple will, and have a testamentary trust in there, especially if you have life insurance. Name the life insurance policy, name the trust, this testamentary trust as the beneficiary. If you happen to get killed out here on Kelly this afternoon and you've got some small children, you've named a trustee in that testamentary trust that the judge has to comport with. And then you've also provided for life insurance that provides money to raise those children. So that works out pretty well, especially if you're just getting started with your married life and your business life. You can, again, I mentioned this earlier, but in that testamentary trust situation, you can also have a testamentary guardianship appointment. Again, the judge doesn't have to follow the guardianship appointment, but normally they will unless there's some compelling reason not to, or some relative comes along and and indicates that the proposed guardian is an alcoholic or something like that, you might run into trouble. But most of the time, they'll take those suggestions and make them into the reality of it.
Does a trustee have to be a certain age?
Well, you would never want to have a personal you would never want to have any of these fiduciaries be anything less than 18. And normally you'd want them to be a little older than that. Maybe someone that's gotten through college, or they've gotten their first job and gotten down the road a little ways, something like that. But yeah, you would want them to be adult. And in Oklahoma, an adult is 18 or older. So yeah, that's a good question though, because some people come in and they talk about, they've moved into Edmond from, New York, and they have no relatives around here, and what are we going to do? And they've got some kids, but they're still in college, and so that can be kind of a problem. So yeah, you need to give some pretty careful consideration, no matter if you're going to do the irrevocable trust or a basic will or this testamentary concept within the will. You got to think about who those fiduciaries are, and that's what all these people are that we're talking about: the personal representative, a guardian, a trustee. All those people have a fiduciary relationship to the heirs.
Can you have like a backup trustee? Or
oh, you always do.
Okay.
No, you always do.
Okay.
We wouldn't send you out of our office, at least, without the primary trustee. And normally in these revocable trusts, the primary trustee is going to be the people who are creating it, and then a secondary trustee, which would be, it could be adult children, it could be an aunt or an uncle or a close friend, or some people like to appoint their CPAs. Some people, with banks, when you have a trust department, some people like to do the corporate trustee with a banking institution. Now, if you do that, and you want to have a banking institution with a trust department be your trustee, you have to get them to approve that first, because they don't want to get surprised with something, and then you'd be in trouble. So, but they'll normally, I mean, if you are the grantor again of a trust, or even a will, and you want to do the testamentary trust, and you're a customer of the bank that does have a regular trust department that operates and functions, they'll normally work with you with that. There's not a real big problem. Normally, again, with a commercial banking institution, you're going to have some fees. If you have a CPA that's not your friend necessarily, you probably have some fees on that. Relatives normally don't charge fees. So, and you may not get the same. Yeah. Now your mom might charge on that.
Do what you can.
But yeah, you got to do what you can. Yes, sir.
Funding the revocable trust. If
Yes.
there's money in the trust, is that the funding? Or do you have to have separate
Well,
funding?
what I mean by that, and it's kind of a term of art, what I mean by that is, let's say that you have a bank account with MidFirst Bank. Okay.
That's good.
Okay.
Everyone should have one.
Exactly. And if you don't, you probably should. But let's say you do, and you got $100,000. To fund the trust, what you would do is you would take your trust memorandum, which is basically a one-page document, because they don't really want to see these 30-page deals more normally. I mean, sometimes they do, most of the time they don't. You take your memorandum of trust down there, it says who the trustees are, the date of its enactment, and you give that to your banking officer, and they open up a bank account now called
That revocable
John
trust.
Ellis Revocable Trust, right? And they transfer that money from John Ellis into the individual in there, and now you've funded that trust.
Okay.
And the other aspects of funding a trust would be to, like, normally if you were going to do this, you would transfer your home and your oil and gas properties if you have any,
And all the
kinds of things.
So if there's liquid money, you've got it in there. It's funded.
If there's liquid cash, you normally would put all of that in there, because again, if you don't transfer that that's what funding really is. It's just a transfer.
Right.
If you don't put that money into the trust, then you've defeated your purpose.
Right. Got it.
Now, and again, LLCs and revocable trust work a lot the same. It's called a pass-through entity. Okay, you get some benefit of a shield, like a corporation shields you from creditors to some extent individually. These kind of things do that a little bit as well. LLCs really do. Revocable trust will have a spendthrift clause in there that does that too. But because it's a pass-through thing, you still don't have to pay tax, twice.
Right.
You only pay tax as an individual,
Right.
even though you have a trust. Now, the kind of the third and final type of trust is an irrevocable trust.
Right.
And with those, you're going to get a tax ID number. It is a
Right.
separate entity. It's
It
like
is,
a
right.
corporation.
Right.
Okay. Like it could be like a sub S corp or a C corp. It's going to pay its own taxes, and you're going to pay your own taxes too.
Right.
So you're going to have that double taxation problem with an irrevocable
Right.
trust. Everybody kind of on
Gotcha.
that. So normally what we would recommend is the revocable type trust. It
Sure.
also gives you a whole lot more flexibility. You can again, you can amend it, change it, do a whole lot of things with it. You know, terminate it if you chose. Although you would, again, you really wouldn't want to do that after you've gone through all those processes, because if you terminate one of those, then you have to do those transfers back to the individuals.
Okay.
But you could do that,
Right.
and they're very flexible,
Right.
and that's what we would normally recommend at our firm is a revocable trust.
You know, just to interject in this, and you're probably gonna touch on it anyway, but back in the day, when I first started doing probates 25, 30 years ago, you just took the death certificate down to Medfirst Bank and they just shifted the account over to the wife. I mean, you know, there's very little, but now after 911,
You have the Privacy Act, you have some other things.
like when my mother died, to get her stock, I had to open a probate
Right.
just to get her stock.
Yeah, Merrill Lynch or whoever it might be, Edward
Yeah.
Jones, none of those entities like that will do that kind of thing anymore. You have to have the proper proceeding. You've got to have what's called letters testamentary or letters of administration in case you don't have a will, and you've got to produce those to the proper parties in these stock brokerage houses before you can get that done. And now there is a concept called a pay on death account, as the bankers are I'm sure familiar with and probably have dealt with many times, that would let you do kind of what Susan's talking about, which is take the death certificate down to the bank and the account gets dealt with. And in some instances, when you've got a relatively non-complex kind of situation, maybe not dealing with a lot of money or something, that would be okay too, if you didn't want to go to the level of a trust. If you had a will and you did the pay on death accounts, the POD type accounts, you can do that. But again, with those wills and with the PODs, you're going to have some. Your heirs are the ones you've put the problems on. Okay. While you're alive, you know what you have, and it's much easier for you as the owner and the creator of those assets to deal with them rather than to put all that trouble and frustration, if you will, onto your heirs. Because again, you know, we've got a pretty transient society. People move around a lot. I mean, you never know where a job's going to take your children after they get out of college or whatever it is they're doing. And so it's just a lot more efficient and probably a money-saving deal in the long run to do your estate planning and do it yourself rather than to leave all the problems, you know, because your heirs are going to have plenty of problems. They're going to have to bury you. You know, they're going to run into. One of my cousins is a funeral director. I know how this works. He claims I get him on the front and he gets him on the back or whatever, but there's some truth to that. And you have these problems that have to be dealt with, much less trying to figure out where the assets are supposed to go and who should get what and all that.
Well, and it's one thing if the heir is a child who isn't dependent on their income, and another if the heir is a spouse or
Right, if they're dependent on the income, right.
who can't handle these delays.
That's right. You can do, in an estate, you can ask for an interim distribution, but the court really doesn't have to do that if they don't want to, if the judge doesn't want to. If there's some reason he feels like the asset might be squandered or wasted, or that there's a need for the payment of debt, then, you know, whatever the debt might be, on the home or whatever, he might not grant an interim distribution, and those people that really need that money pretty desperately might be in trouble at that point. So that's another good reason to do the trust, the revocable trust, because the income stream continues on, and the ability to pull money out of a checking account continues on. So those are good reasons to do the revocable trust.